mass violation of human rights does not necessarily have to be genocide. Genocide is a form of violation, of course. However, violation of human rights can take in various forms, and it is submitted that the mere fact that the actus reus has been found by the joint panel is sufficient to satisfy the limit of violation of human rights for the purpose of.
So your argument is that the dissent does not detract from the factual basis of a human rights violation that had occurred within their territory.
Exactly, Your Excellency, and rather support that the report was balancedly made.
Can I come to this genocide? I think the compromise mentioned that the only instance of possible genocide is the forcible transfer of children. Or in real life, Australia was accused of allegations of genocide. In fact, the commission report by the Judge Ronald Wilson said that in a sense it amounted to genocide, the forcible transfer of children. Can Indonesia or Japan invade Australia because they have committed genocide by forcibly transfer the children? From your analogy.
Your Excellency, that's absolutely not the case. If the Japan and Indonesia analogy prevails, that would be a case of humanitarian intervention. However,
but suppose Aborigines from Australia had fled the oppression to Japan and had flooded the Japanese cities. Would that be then a good reason for Japan to intervene?
Your Excellency, still not, since the case
if
was...
that is not the case, then what business were you doing across the border?
Your Excellency, the prime distinction...
You've just demolished your own case, haven't you?
Absolutely not, Your Excellency. That is a case of humanitarian intervention, simple and pure. However, the violation of human rights is relevant. It's only a criteria to evaluate whether or not the people of Akiva has a right to succeed. That is two distinctive scenario under international law. We never rely on the pure and simple humanitarian intervention doctrine under international law, and we accept that it is still unsafe to rely on by the respondent as a claim before Your Excellencies.
I think you've got 5 minutes to put the rest of your case to us.
Thank you, Your Excellencies. The impossibility of peaceful solution is, of course, apparent on the fact that 4 years of war has gone on between Donovan and Akiva. No attempt has been made by the Donovan Union to stop the war, and it was them who first invaded the province of Akiva. Impossibilities is self-evident on the fact.
Did they invade the province of Akita, or did they? I think the the compromise mentioned that before independence was declared, the subjugated, the constitution was suspended. So it is technically, factually, not a state, and so you cannot use the word invasion. You can. They will definitely argue, and they have argued, that it is a suppression of an internal rebel movement.
I apologize for a loose use of the word invasion. It is a submission, on the contrary, that on the respondent, that the reassertion of the armed control, more neutral term, would prove the...
Can I give you the example of the Philippines? And you give me an answer to that. The Moro rebellion wants to secede from the south. The Philippine army has gone in and has prevented them from doing it. Apparently there's a country nearby called Malaysia, which wants to send its forces to assist the Moro rebels, because they have now come into another lesser known place called Sandakan, taken over. In those circumstances, is it proper for this country, Malaysia, to lend armed assistance to the Moro rebels?
If Your Excellencies, the case can be proven according to the criteria laid down by the respondent, we will submit that yes. However, on the facts of the case, we see no reason why we would likely infer.
Extend by 2 weeks.
Likely infer that those Liberation Army constitute a people, and all the criteria are satisfied on the facts of Your Excellency's case.
No, you're not answering my question. You're answering some other question, which I never asked.
The question, Your Excellencies, if I may clarify, is that whether Malaysia can assist the National Liberation Army.
Because they say they look at the words, Liberation, Moro Liberation Front. They want to liberate the island, the southern part of the Philippines, in the now south, and they want to declare themselves a separate state. The Republic of Philippines has gone in with their forces. I've given you the example of the exodus of Filipinos into a state called Sabah. right? Somewhere on the map, right? And they've come in there, and now the Malaysians are flooded with Filipinos in Sabah. They want to send their army to the southern Philippines so that they can assert, the Moros can now assert their independence because they are not rebels. According to you, more or less, the geographical territory is approximately all right. Or approximately there is a state. Approximately they are able to declare themselves separate. Therefore, the presence of the Filipino troops must be illegal. Therefore, we can go in and invade. Not we, Malaysia can go in.
Certainly, Your Excellencies, we must appreciate that there are more criteria to be satisfied for foreign invasion, even if that particular.
So, what are the additional, briefly, what are the additional criteria that are fulfilled in the case of Agita vis-a-vis Donaville, vis-a-vis Babanggan, in contrast to the Filipino-Malaysian situation?
Certainly, Your Excellencies, it will be submitted that on the facts of the case, there are, the difference here is that there has been total and effective declaration of democratic participation here, but it is not apparent on the facts.
Time is extended by 2 minutes.
Thank you.
To wind up.
Yes, certainly, Your Excellencies. And just to summarize the answer to Your Excellency's question, the principal distinction would be that there is no apparent total frustration of democratic participation in the state of Philippines up to date, and that would be the crucial distinction to make here. In conclude, it must be a very important point should be made in the sense that a right to assistance can be satisfied by direct military intervention, and it will be shortly submitted that this is recognized by, of course, the United Nations General Assembly Resolution 3317, defining the acts of aggression, and it's recognized that assistance given to.
Coming to aggression, it is again, I raised the same question to your opponents, regarding self-determination, regarding permanent sovereignty, regarding CERDS. How strong is the definition of aggression in 1974 and it's now 2008? The Rome Statute cannot define aggression because of controversy or that. So how strong is this resolution, even as a persuasive authority vis-a-vis before the court, in contrast to the arguably stronger decolonization resolution and permanent sovereignty resolution?
Your Excellencies, it is submitted that one of the Article 3G of the definition of aggression has been recognized by this court in Nicaragua as constituting customary international law. Of course, that has no bearing on our submission on the other parts of the definition of aggression. The paramount point here is that the definition of aggression, the exception to assistance of self-determination, refers back to the Declaration of Friendly Relation in 1970. And the Declaration of Friendly Relation has been widely accepted by publicists and states as constituting customary international law, and that would add force to the exception recognized by the definition of aggression resolution. And in fact, this interpretation, the exception argument, is being accepted by states from all 5 continents around the world. By the states.
I'll ask the same factual question that I posed to your opponents. I asked them about damages. Can you give any example, not necessarily of this court, but any United Nations bodies which have found a particular state to be quote unquote guilty of aggression under the resolutions or under the definition you have given?
Your Excellencies, the closest example that I would give is the Security Council resolution given, perhaps this number is 244, in relation to the Congo's affair rendered in the very early era of the United Nations. And in fact, the Security Council expressly recognized that certain acts done by Angola against Congo as armed attack and aggression in French, of course, and that's